was just raising the same argument as yesterday in regard to the last two counts, which is aggravated child neglect and especially aggravated kidnapping.
Aggravated child neglect, Your Honor, the defendant knowingly neglected Kennedy Hoyle as to adversely affect Kennedy Hoyle's health and welfare. The state of Tennessee put on proof that through the defendant's confession that he placed Kennedy Hoyle, he stated that he placed Kennedy Hoyle on the riverbank, but later admitted to throwing her by the leg into the Wolf River. Your Honor, that she also was never found. That adversely affected her health and welfare. She is deceased. Even by laying her by the river, that resulted in her dying as well. He took baby Kennedy from the back of the vehicle after shooting Danielle Hoyle. He said that in his statement. And he drove with her, I think, for approximately an hour and a half before he admitted to throwing her into the Wolf River. By doing so, he substantially interfered with her liberty. He, at that time, was not a father listed on the birth certificate. He also did not have parental rights at that time as far as that would have been established. And so he did not have a legal reason to have baby Kennedy with him, but also taking into consideration the facts that he had just killed Danielle Hoyle based on his statement and the evidence presented by the state of Tennessee during the course of the trial. He unlawfully interfered with her liberty. And as a result, or during the course of, she suffered serious bodily injury during the removal confinement. She is deceased as an act that continued during the course of the especially aggravated kidnapping. For those reasons, the state would submit that a rational jury could find the defendant guilty of both of those counts beyond a reasonable doubt, and therefore ask this court to deny defense counsel's motion for judgment of acquittal at this time.
At the conclusion of the state's evidence, the defendant may move, as he has twice now, to ask for the trial judge to consider a judgment of acquittal. When confronted with a motion for judgment of acquittal, the only concern of the trial judge is the legal sufficiency of the evidence and not the weight of the evidence. Respectfully, Mr. Massey, I will have to deny your motion for judgment of acquittal. I do believe that in viewing the evidence provided in the state's case at its best light, it would be inappropriate to dismiss the first-degree murder counts in count 1, 2, and 3 of the indictment, or disturb the indictment on counts 5 and 6.